it starts from page number 13, and 14 is the cross-examination. Now, if I may take your lordship kind attention to paragraph number 5.
No, madam, we ask you to examine the matter from different perspective.
Yes.
You see, in the judgment, there is no point for determination.
There's no point for determination.
Yes. Have you gone through the provision of section 393 of BNSS?
Yes, your lordship, I have gone through, and it is, if your lordship is of the opinion that it should be remanded on that question alone, I do not have any objection.
You have no objection.
I do not have any objection. However, it's in my humble opinion, the age of the prosecutrix is proved.
How?
Because in the cross-examination itself, in paragraph number 5, she have stated that exhibit M1, which highlighted my date of birth, had a hole and my date of birth written as 10/2/2006, while my exact date of birth is 14/2/2006.
Where is the documentary proof?
The documentary proof is the
That the Xerox
page,
copy of the
yes,
certificate?
the Xerox copy, the attested copy of the birth certificate.
Attested copy.
Attested copy. No
Can it
doubt,
be,
this is a secondary
so
evidence.
Can it be said that the age of the victim has been proved beyond all reasonable doubt?
Your lordship, there is no questions, or the learned trial court did not go into that effect.
You answer my query.
Yes. Your
Can it
lordship,
be
in my
said that
humble
the case
opinion, it is proved.
the age of the victim is proved beyond all reasonable doubt?
Your lordship, in my humble opinion, it is proved beyond reasonable doubt.
On the basis of that attested copy of the Xerox
On the basis of
birth certificate?
the attested copy, which is not disputed, the secondary evidence is not disputed. The existence of the birth certificate is not disputed. However,
you
they
see
have...
her cross-examination, there she has admitted that she has written the date of birth there.
Yes, yes. She have stated that, but then in the cross-examination itself, she have stated that 14/2/2000.
So examine that aspect, because this is first appellate court.
Yes.
Okay, we are setting aside the impugned judgment and
Okay.
order, and we remand the matter to the learned trial court.
Apart from that, Like I mentioned regarding hearing list,
Yes.
item 8, 9 and 10 are taken together items. Item 8, 9, 10, 11 and 12 along with 17 may kindly be taken up after 3 weeks, my lord.
8, 9, 10.
Yes, 8, 9, 10, 11, 12 and 17. These
12?
are all criminal appeals.
12.
12 also, your lordship, and 17.
Seventeen.
17 also, your lordship.
Okay. On the pair being made by Mr. So-and-so, learned counsel, you are for the petitioner.
I am for the appellants, your lordship, yes.
Learned counsel for the appellant. You inform the other side
Yes, my lord.
with consent from the other side. Press for listing the matter after 3
After
weeks.
3 weeks, my lord.
After 3 weeks. Fair allowed. Press to list the matter after 3 weeks.
Much obliged.
Mr. Lordship, I have a fixed item number 3 of hearing list today.
Yes.
Lordship, I have personal difficulties, and
Perfect.
item number 3 and 4 may be taken up after holiday.
Okay.
Yes. Okay.
Miss Dinarity Azure. Learned senior counsel. With consent from the other side, press for listing the matter after vacation.
Yes.
Okay. Fair allowed.
Much.
My lords, item 18 of part 2, my lords. This may be
Item?
fixed. 18, my lords, part 2. Hearing is. Lords, this may be, my lords, adjourned to my lords next week, Thursday, which is the 2nd of July, my lords. We have taken consent from the other side.
Mr. Jordan, learned counsel for the petitioner, with consent from the other side, press for listing the matter on 3rd of July.
3rd of July, my lords.
3rd of July. Fair allowed.
I'm sorry, my lords, 2nd of July.
2nd of July. Fair allowed.
Obliged.
Lordship, in respect of item number 16, I have taken consent yesterday. So, my lord, today I had family matters to attend. So I had spoke to even government councils also.
You are for the respondent number?
5.
Sir, your name please. Learned counsel for the respondent number 5. With consent from the other side, press for listing the matter.
Actually, last night we say after vacation.
My lord,
after
it is a
this-
part heart, and
don't know
if it
whether
is
it-
not possible today, then it can be can it be tomorrow or day after tomorrow? Because it is a part heart. My lord, it is a fixed matter
Okay.
for today.
So what is the difficulty?
My lord, I have to attend the marriage function. The prior engagement we had it. That's
Tomorrow is there is division bench tomorrow
After DB also, can it be
after
possible?
DV.
I'm fine.
Friday is holiday.
Actually, last night when I talked, can it be? She proposed that it can be listed after vacation, and that part of matter can be released.
No, this is part third matter.
Yes,
So tomorrow after DV.
that's fine, Lordship.
Okay. It's agreed by learned advocates about the parties. This shall list the matter tomorrow after DV.
Much obliged, Lordship.
Much obliged.
Prohibition, item number 1 to 6.
Lordship, this item number 1 to 6, they are more or less similar matters. They all tagged together. At the same time, Lordship, item number 6, there has been final agreement, final conclusion of the matter between the petitioner and the respondent state. So this matter may not be pressed. Item number 6. It may be disposed of as not pressed.
Okay. Not press or withdrawal?
Not pressed, Your Lordship.
Not press. Okay.
So far as the other items are concerned, Your Lordship, if this matter can be taken up for final hearing on next Thursday.
Next Thursday.
Yes, Your Lordship.
Mr. So-and-so, learned senior counsel for the petitioner, with consent from the other side, submits that this item number 1, 2, 3, 4, and 5 may be taken up on next Thursday.
All right.
We are allowed. In respect of item number 6, you take down the learned senior counsel for the petitioner submits that the petitioner is not willing to press this matter, and as such, the same may be closed. Accordingly, taking note of the submission of learned counsel for the petitioner, this matter stands closed.
No plus.
Item number 7.
My Lord, in this matter, the newly imputed respondent, number 8, is yet to file the affidavit in opposition. But till now, they have not filed. I believe that they are not interested in this case. And if their chance may be closed, the respondent number 8 is the additional DC Kamkala, National Highway Authority, my Lord. All the respondents have filed except respondent number 1, whose chance has been closed, and the remaining is respondent number 8. The respondent number 8 has engaged Ms. Lalun Luigi.
So other respondents have filed their affidavit.
Yes, my Lord, except respondent number 1.
8.
Respondent number 1, the chance for submission of WO has been closed, and now the remaining is respondent number 8.
Oh, who is appearing for respondent number 8?
Lordship, Ms. Lalundu is appearing. However, she is having some personal difficulties today. So, if at least 2 weeks' time is given to file her affidavit.
My Lord, she has nothing much to say as per the affidavit of the respondent number 7, who is the Deputy Commissioner, who has already filed the affidavit. It is only on the fact that the additional Deputy Commissioner has made an assessment. Apart from that, there is nothing to mention on the part of respondent number 8. This is a matter relating to National Highway Act and non-payment of the rehabilitation and resettlement entitlement, which is provided under the 2013 Act of the Right to Fair Compensation, my Lord. All the landowners have been paid compensation except the tenants of the landowners, who has to be paid as per the second schedule of the 2013 Act.
Okay.
Your Lordship, let her get the instructions. I will inform her.
Okay.
If I may just submit that GA has filed her affidavit on 17/2/2026, her vakalatnama. She has received the copy of the petition on 18/3. Now more than 4 months has lapsed.
Okay. Last sentence.
Last sentence, my Lord.
Last sentence.
Let it be a fixed date.
Yes. Heard. Mr. C. Lalfakzwala, learned counsel for the petitioner. And Madam for respondent number
Your Lordship, for respondent number 5, 6, and 7.
5, 6, and 7. Not for 8.
For 8, I'm appearing on behalf of Ms. Lalundu.
And for respondent number 8. And you for?
2 to 4, ma'am.
2 to 4.
Yes, ma'am.
And Madam, you were not there.
Madam Sampu is in.
Your respondent number?
Number 1.
1.
She's number 1, I'll say for her. No, her chance has already been closed.
Okay.
She has missed the bus.
The learned counsel for the petitioner has pointed it out that the respondent number 8 has not yet filed the counter affidavit. The learned counsel appearing for the conducting counsel of respondent number 8 submits that she will inform the conducting counsel for the respondent number 8 about filing of the counter affidavit. Accordingly, taking note of the submission of learned counsel for both the parties, last opportunity is granted to the respondent number 8 to file counter affidavit, and Justice shall fix the matter immediately after reopening of the vacation.
Can it be before the vacation, my lords? 2nd July?
2nd July.
2nd July.
Your
Okay.
Lordship, if it can be fixed after vacation.
No, they were granted time, and
Immediately after the
if I may
vacation.
be
Your
given the
Lordship.
benefit of the date.
2 weeks.
Okay, let us try before the vacation
My lord,
on 2nd of July.
obliged.
Item number 8.
Lordship, in fact, this matter, attempt was made, even the order reflected that attempt will be made to dispose of the matter. But I don't know today,
Pardon?
government advocate is not available again today, whether we can dispose of or not.
Advocate for the respondent number?
Respondent number 1 to 4.
The counsel for the respondent number 1 to 4, she's having some personal difficulties today. So if the matter may be taken up on any date.
My Lord,
convenient to
actually,
the
even
petitioner.
I specifically pray that no more adjournment, because even on last occasion also, it's happened like this. We could not. I prepare compilations of my judgment also. I already furnished also. I also come all the way from Delhi, and I have my flight on 26 going down to Delhi also. I'm fully prepared, Your Lordship. At least, my Lord, one aspect of my prayer can be considered today.
No, we will finally hear the entire matter. Can it be on Thursday?
My Lord, that's up. I'm ready, Lordship.
Yes.
Yes, Your Lordship, I will inform her.
Or at least, my Lord, it can be taken up first week of July also.
First week of July.
Because that Thursday I have one fixed matter also.
First week of July.
Yes.
Okay.
And it-
As agreed by
My
learned
Lord,
advocates
my
of
Lord,
both the
before
parties.
that, one aspect is that this is regarding this thing, mob violence. Then they burn to our house and destroy property. In that respect, FIR was lodged by the police on 29. That before hearing at least that the status of that FIR, Suomoto FIR, can kindly be informed, apprised to the court. What is the status? Because there is Supreme Court judgment, Tashin judgment, the law is very clear that regarding that mob violence, vandalism, and prompt action should be taken. There will be a special court, and it should be done within a specific time. So that really requires immediate action. But now, till now, though it was happened on 27 night, and FIR was registered on 29, until now, no arrest was made. We are not sure whether case was registered or not. At least that aspect, because at the times of hearing, we require to deal with on that aspect.
Okay. As agreed by learned advocates of both the parties, VSS shall list the matter on 1st of July.
Yes, Lordship.
1st of July. And on that day, learned counsel for the respondent number 1, 2, 3, and 4 shall apprise this court about the status of the FIR lodged by the petitioner herein.
My Lord, that actually Suomoto FIR, it was
Suomoto
registered by the police themselves.
Okay. In respect of the Somoto FIR registered by Which
The
police
police.
station?
Vaivakon police station.
Vaivakon police station. Somoto.
So whether any arrest or anything done that in respect of the status of the investigation.
Status of the FIR.
That's fine, Your Lordship.
Yes, they will inform this court on that day.
Fine, Your Lordship. Much obliged.
Item number 9.
May it please your lordship. My lord, this present appeal is against the order dated 17/4/2026 passed by the Honorable Civil Judge in civil suit number 15 of 2025, wherein my suit was dismissed as barred by limitation. However, my lord, in this case, my lord, the appellant was earlier granted heirship certificate in respect of the instant suit property back on 2004. And this court in writ proceeding had set aside my heirship certificate in the year 2016 by judgment and order dated 12/2/2016. Thereafter, I have preferred writ appeal before the division bench, which was pending for several years and which was ultimately withdrawn on 17/12/2024, December 2024. Thereafter, on February 2025, I have filed the suit. In the writ petition, wherein my heirship was set aside, my lord, the liberty was granted to the parties herein to approach civil court for declaration of their rights. However, being aggrieved against the judgment order in the writ petition, my lord, I have preferred an appeal, which was ultimately withdrawn on December 2024, meaning thereby, my lord, my suit come under the exclusion under section 14 for time spent in bona fide in another proceeding. In spite of that, my lord, the London trial court had dismissed my suit on the ground of limitation.
No, whether you have taken the plea of section
Yes.
14?
Yes, my lord, specific averments was made that the cause of action firstly arose when the writ court set aside my heirship in the year 2016 by giving liberty to the parties. Thereafter, I have preferred an appeal, and ultimate withdrawal of the appeal, another cause of action arose. And another thing is that, my lord, on the other hand, the respondents herein, they kept silent after 2016. But after I filed my suit, they have preferred counterclaim. And the London trial court held that while dismissing my suit, it held that the counterclaim is maintainable. This is the first time.
Let notice go at this instance.
Yes, my lord.
Heard Mr. Altel, learned counsel for the appellant. This appeal under section 17(2), Certificate B of the Mizoram Civil Court Act 2005, reduced section 96, and order 41, rule 1, and section 151 of the Code of Civil Procedure is directed against the order dated 17/4/2026 passed by the learned civil judge senior division number 5 Aizal in civil suit number 15 of 2025. It is to be noted here that by the impugned judgment, the impugned order dated so and so, the learned trial court has dismissed the suit of the appellant being barred by the law of limitation. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned order dated so and so. Admit, issue notice to the respondent, returnable in 2 weeks or 4 weeks.
In view of the ensuing vacation, my lord,
After
3
4
weeks.
4 weeks. 3 weeks.
4 weeks will do.
4 weeks. Returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Additionally, dusty service is also permitted. And after effecting service by dusty mode, the appellant shall file an affidavit before this court. This after 4 weeks.
TCR may be called for.
SSL call for the scan copy of the TCR.
IA is there, my lord. IA number 123 of 2026.
For
Seeking for stay of the proceeding because counterclaim is going on. In the event of allowing the instant appeal, my lord, if they proceeded with the counterclaim, recourse will have to be made and it will be amounting to abuse of the process of the
Heard,
learned trial
Mr.
court.
Ralte, learned counsel for the applicant. This application under Order 41 Rule 5, rated Section 151 of the Code of Civil Procedure is referred by the applicant for staying operation of the impugned judgment and order dated 17/4/2026. Execution proceeding has been
No, my lord.
started.
No, my lord, the counterclaim, the trial of the counterclaim.
Okay.
No separate registration number was given in the counterclaim. It comes under the registration of civil suit.
Okay. The learned counsel for the applicant submits that connected appeal has already been admitted for hearing and the record has been called for. Analysis, there is a requirement of a staying operation of the impugned order dated 17/4/2026. Accordingly, taking note of the submission of learned counsel for the applicant and also considering the facts and circumstances on the record, impugned order dated 17/4/2026 passed by the learned trial court in civil suit number 15 of 2025 stands stayed till returnable date. They stopped. No, not till returnable date. Stayed till disposal of the appeal. In terms of this, IA stands closed.
If I may, my lord, one more point. To avoid interpretation of the order or avoid confusion, my lord, if specific direction may be made, apart from staying the impugned operation of the impugned order, my lord, the proceeding of the civil suit may also be stayed.
May not be necessary. May not be necessary because the trial court has decided to proceed again or proceed the
I understand. I
counterclaim
understand.
by the impugned order.
Yes, ma'am.
If we state the impugned order, then automatically that counterclaim will be stayed.
Yes, your lords. Deeply obliged.
Item number 10.
Yes, Your Lordship, I'm representing the respondent number 2, which is the state respondent. And I'm seeking another 2 weeks' time to file my affidavit.
My lord, similar prayer for respondent number 1.
Same prayer for respondent number 3.
Who is for the petitioner? None appears for the petitioner on call. How about Ms. So-and-so, so-and-so? Learned counsel for the respondent number 1, 2, 3, and 4.
Only 2.
You are 2.
Yes.
You are 1. You are 4? 3.
4.
4. Are present and praised for granting 3 weeks time to file counter affidavit. Counter affidavit. Where allowed, list the matter after 3 weeks. In the event of subsequent non-representation of the petitioner, appropriate orders shall follow.
Item 11.
My lord, I have instructions from my client to withdraw this matter with the liberty to file a fresh, my lord.
Why?
Because he said that he is not able to comply with the direction of this honorable court by depositing the amount
Okay.
as of now, because he is facing some medical complications.
Today, my lord, I'm ready to file my power, but since my friend is going to withdraw the case. But as per the order of this court 26/2026, if your lordship allow me, the petitioner has to pay 8.2 lakhs to the respondent number 1. That has not been complied, my lord.
There is the reason why, your lordship, the problem he is facing is he has been suffering from several illnesses till today. So while he was trying to sell his excavator, that also failed. So the instruction I got from the petitioner is that I asked him that I may withdraw myself from being the counsel, but he said that instead of doing that, let me withdraw if the Honorable Court permits, and with liberty to file afresh, and whenever I will be able to make a deposit of the amount or to pursue the matter, so he will file it again. But subject to this Honorable
Mr.
Court.
Counsel, you see, if we allow you to withdraw this petition, it will amount to allowing the petitioner to flout the order of this court.
Yes, my lord, correct.
If I withdraw the writ petition, my lord, then the respondent, the present respondent number, the respondent will be having a liberty again to pursue the execution case which is pending. So from that execution case which is pending, then he can still squeeze out the amount.
Execution
Case is pending in respect of this Lok Adalat award. So there won't be any loss for the present respondents also, madam.
No, execution of that Lok Adalat award.
Yes, it is still
That
pending.
case is pending.
Yes.
Yes.
So there will be
Correct,
no
it's
harm.
pending, but however, my lord, I believe that at this stage, if your lordship may permit me to say this, since there is a specific direction to the petitioner to deposit 8.2 lakhs. Now, if he withdraws that amount, then he will roam freely and would not like to comply with the order of the court.
No, your execution case is there.
It's there.
Attachment order is there.
Even if he wish not to deposit the amount before this court, what this court will do?
My lord,
This is writ petition.
correct. Since there is a specific order already passed by this court on 8/2/2026, this honorable court can either allow this petition, the petitioner to withdraw by paying 8.2 lakhs to the respondent number 1. There is the condition which can be said by this court, my lord.
No, your lordship, my learned friend was not there on the last occasion when this honorable court took up the matter. I had submitted clearly before this honorable court earlier that this fixed deposit cannot be taken out except with the consent or prior consent of the PWD department. So PWD, it is regarding the running bill regarding one contract work. So that is put as a fixed deposit in Yes Bank, and it cannot be taken out. If I'm allowed to take out, then I should have deposited already in this honorable court. But anyway, your lordship, withdrawal of the present writ petition will not detrimentally affect the interest of the respondents, because execution case, there is already an attachment order as well. Due to this honorable court's order, stay had been granted temporarily, and if I withdraw it, so I won't have any protection, my lord. So they can take whatever necessary action against me.
Go for execution then.
My lord, things are not as easy as it seems as my learned friend submits. Since we have the protection of the order of this court, the benefit of this honorable court, that we are expecting that we will receive 8.2 lakhs. It is only due to the insufficiency of funds that we could not receive the 8.2 lakhs. There was a check bounce case, which I think my learned friend has submitted in the earlier court date. So if your lordship permits withdrawal of this petition subject to payment of 8.2 lakhs, which the petitioner has undertaken in the last court date, the disputed amount is 13 point something lakhs, the Lok Adalat award, and they are ready to pay 8.2 lakhs, which was submitted.
If execution case in respect of that amount is pending before the learned executing court, then how prejudice will be caused to you?
No, my lord, we would like to take the benefit of the order of this court passed earlier on
No, that's all right. That's why I'm putting the question.
my lord.
If he refuses to pay the amount before this court, what this court will do?
He cannot refuse, my lord, because this is the order which is going to be passed by the writ court, which power is much higher than the district court, my lord.
No.
That cannot be there, madam.
Because he has sufficient time to
I think-
escape the
I think my learned friend doesn't
This
understand.
court cannot act as a recovery agent.
Hmm.
There are several decisions of Supreme Court. Red court cannot.
I submitted earlier, I submitted in the last court date also that it cannot be used as a recovery for money in other cases. But since there is a specific order passed by this court on 2/6/2026 on the undertaking given by the petitioner that he will pay 8.2 lakhs. My lord, if your lordship may kindly see the last order, my lord.
Yes, I have seen it.
Yes, my lord. So if a man undertakes something that he will do, and he has to do that, my lord.
Okay, you
Yeah.
deposit the amount before the trial court, executing court.
Your Lordship, the protection given to me by this honorable court is subject to depositing of that amount only. And if I withdraw the matter, protection will also be gone, my lord. So in that regard, what will happen is that in execution case which is pending, I have annexed in my writ petition at page 40, my lord, 40. This is the attachment order already passed.
Attachment is a different thing.
No, it's not a different thing, your lordship.
Undertaken
It is
given
for
by the petitioner to pay 8.2 lakhs is also a different thing, my lord.
just at page 40, your lordship. This is the attachment order. So it will be enforced. This will be enforced accordingly, my lord, because if there won't be any stay,
But even if these articles are attached and put in auction, whether the amount can be recovered, whether it will be sufficient.
that is not, the valuation is not taken, my lord. It's a bit difficult for me to say.
Your liability is 8.2 lakhs.
As per their acceptance. As per their acceptance. As per the law.
Yes, but there is also the disputed question of fact still remains is that to whom it is payable. That is still the question, my lord, to be answered. Because the present
Why
respondents,
already there is one decree against you.
yes, there is a
means
loc
what?
adalat decree award.
That means what?
That means, but in the petition also, the present respondent number 1 said that the work was executed by him along with his friends. That was stated clearly by the present respondent number 1.
No, in this petition we cannot decide those issues.
Yes. So what I'm submitting is that, your lordship, I may kindly be allowed to withdraw it, then I won't have any protection. So whatever actions they can take, then I have to face it.
Subject to payment of 8.2 lakhs. As
That-
undertaken by him, my lord.
That question, if direction was given to me only to make a security for this in respect of the stay which was granted to me, my lord.
Otherwise, it might amount to an abuse of the process of the court.
No, it cannot be, my lord.
Because he was directed to pay 8.2 lakhs while the case was admitted. This case was admitted only due to the fact that he was directed to pay 8.2 lakhs. Due to check bounce case, we did not receive 8.2 lakhs.
No,
as
check
per-
bounce, this honor of check, it's a different matter. There is no action or criminal complaint taken against me, my lord.
Now,
And this honorable court also considered that earlier, and that was why I was given further time. Your Lordship, now everything is revealed, like pertaining to that fixed deposit also. I have mentioned about that fixed deposit as well. So if they want it, they can pray before executing court to attach that fixed deposit as well. That can be done.
execution,
Earlier they may not know about that, but I have mentioned everything under oath in my writ petition. So it will be more appropriate, Your Lordship, if that can be attached.
Okay,
No,
you go and file
yes.
an application before the executing court.
That will be more appropriate.
execution proceeding is a different thing, my lord, with due respect to your lordship suggestion.
Pardon? Pardon?
With due respect to your lordship suggestion, execution proceeding is a different thing. And another aspect is that since my learned friend has undertaken to pay 8.2 lakhs, that is, I mean, the petitioner, and if he withdraws this case, then he will be free of that 8.2 lakhs till the disposal of the execution proceedings. The execution proceeding is only for the attachment of this property, which we do not know the value, whether it will fetch this 8.2 lakhs or not.
No, then you can proceed against the fixed deposit amount. You file an application before the execution court
That is correct.
to attach that fixed deposit amount.
I can give him the details also, my lord.
The only aspect which has to be dealt as of now is whether the petitioner has the right to withdraw this writ petition without payment of 8.2 lakhs, which he has undertaken in the last court date. This writ petition has only been admitted only due to the fact that the petitioner has made himself liable to deposit 8.2 lakhs. Now,
No,
if he were given liberty,
Mr. Counsel, you
Well-
say otherwise also this writ petition is directed against one judicial order. Right?
Lok Adalat award.
But whether this writ petition is maintainable or not, that is also a question.
That is another question.
Another question.
Another question. My humble prayer is that since a man has undertaken to do something and which has been accepted by this honorable court and
No,
which is reflected in the
that
order.
is there, but it is his writ petition.
Yes,
If he
ma'am.
is not willing to pursue the same, then what to do?
If he is,
You are not remediless.
yeah, correct.
Your
Malot, yes.
execution case is pending. You can rightly proceed with against him.
Correct, Malot. I
The
agree.
protection granted by this court will be vacated today itself.
Yes.
Most respectfully, I agree with your lordship. But however, Malot, if your lordship may kindly record our prayer that subject to the payment of 8.2 lakhs, this writ petition can be withdrawn.
No, that cannot be because that order is passed only in this writ petition.
Yes,
If the
yes,
writ
Malot.
petition is withdrawn, that order gone.
Malot. So if your lordship may kindly make some observation that the petition herein may be directed to comply the order, Malot.
No question of
That is
No,
my
no.
prayer today, Malot.
Had it been finally disposed of
Malot.
after hearing both the parties, then the matter would have been different. Now he is willing to withdraw this petition.
Malot, my apprehension is that this is an abuse of the process of the court.
No, but may not be because the question of maintainability of this petition also arises.
That is
Whether
due-
against a judicial order, a petition under Article 226 is maintainable or not.
It's a local adalat
But
what
it
is
is well settled that against judicial order, 226 is not maintainable. 227 may be,
yes, Malot. Malot.
not 226.
There is an order which was reflected in this 10-26 also, Malot. 2626 order
Regarding?
regarding that maintainability. Your lordship may come to 262026 order, page 2, para 3.
Lordship, one submission I would like to have is this direction to deposit 8.2 lakh. Direction was made pertaining to the stay which was granted to me, the protection which was granted to me. And as if I have said, Your Lordship, if I'm allowed to withdraw it, then I won't have any protection. And they can pursue the execution case over there. Now the materials, they already had it, like regarding fixed deposit as well. And I'm the writ petitioner, and if I pray for withdrawal.
You
then-
furnish the particulars of fixed deposit?
Yes. I'll hand it over right now, my lord.
My lord, in that case, we withdrawal with no liberty. With no liberty to file afresh.
There won't be any harm, Your Lordship, if I have the liberty as well.
Otherwise, my learned friend will dictate where we should go around, my lord.
No, liberty I may kindly be given. Otherwise, Your Lordship, then suppose the present petitioner approaches this court again, this honorable court again, then all this, what had already happened in the present writ petition can be raised by the other side also.
Supposing he come again to the writ court, and he again pray for stay of that execution proceeding. We do not know, my lord, because now he's going to dictate where we go to the court. So my only objection is that if this honorable court allows his writ petition to be withdrawn, there can be no liberty, my lord.
No, it cannot be done in that way as per what he said, Your Lordship. Because the liberty may kindly be given to me to maintain fairness also, my lord. And suppose the writ petitioner approaches this honorable court again, then that question can be raised by them. Liberty will be kept open to them also, my lord.
He is definitely going to pray for stay.
And they
of
can file
execution.
caveat also if they want. They
So
can file caveat.
That would be abuse of the process of the court, my lord.
It
To my
cannot be.
humble understanding.
It cannot
If
be.
he wants to continue with this, let him continue. We have no objection. But if he wants to withdraw, our objection is that no liberty.
That is one aspect of why should I grant you liberty then? If you are not willing to pursue this petition.
Because, Your Lordship, if liberty is not given to him, there won't be any other scope for approaching this honorable court again to challenge the Alok Adalat award.
No, yeah, you have already challenged it. Now you are willing to withdraw the same. Then why should we again allow you to approach this court again?
That is the reason is that, Your Lordship, due to his illness, he could not make a deposit of that 8.2 lakh.
No, that is a different aspect. We can grant you time also to deposit the amount.
Or then if time could be granted to me, my lord, as his earlier suggestion, I may be allowed to withdraw this writ petition with liberty to file afresh, and I may be directed to deposit the same amount before the executing court, but time frame may kindly be given further time. At least that can be done, Your Lordship. Instead of further troubling this honorable court, that will be the same thing.
Yes.
If I'm given 1 month at least, then I will sell my excavator also. So I'll deposit in the executing court.
My lord, we need to have a more concrete undertaking from the petitioner, my lord.
Undertaking in respect of?
In respect of whether he would deposit 8.2 lakhs. Because there is already order, my lord.
No, that counsel for the petitioner has submitted before this court
Yes, my lord.
that he may be granted some time to deposit the amount before the executing
My
court.
lord.
Why should we disbelieve him? He is the officer of the court.
Yeah, I don't disbelieve him, but I disbelieve the petitioner.
No, that,
I
your
accept
lordship,
his submission.
if the direction is there, and if the writ petitioner doesn't comply, then he will be arrested. Then still there is an option for attachment of the fixed deposit as well as his other properties also, my lord. Instead of closing the door for approaching this honorable court again, if I'm allowed to withdraw it with liberty to file afresh, then direction may kindly be given so that I will.
You see,
Hmm,
granting liberty to approach this court again,
my lord.
that may amount to abuse of the process of the court.
Correct, my lord.
Because your contention is that you are not in a position to deposit the amount of rupees 8.2 lakhs before this court on account of your illness.
I understand, my lord. And if my learned friend is raising that such strong objection, your lordship, then I will not withdraw it, and I may kindly be given further time, so that I will try my best to make a deposit.
Yes.
We
Yes.
accept it. We accept it, my lord.
At least 1 month may kindly be given to me, my lord. In that case,
Okay. Okay.
yes.
Heard
That
Mr.
would be
So-and-so,
fine with me,
learned
ma'am.
counsel for the petitioner. Then Mr. So-and-so, learned counsel for the respondent.
Respondent number 1, my lord.
Respondent
I'll
number
file my
1.
power, my lord.
Who is for the other respondent?
Other respondent, your lordship,
He is not represented today, my lord.
yes, although we have already taken steps against him.
Okay. On the appeal being made by learned counsel for the petitioner, further 4 weeks time is granted to deposit the sum of rupees 8.2 lakhs before the registry of this court pursuant to the order dated
2/6.
2/6/2026. This shall list the matter after 4 weeks.
Much obliged.
Item number 12.
My lord, 10/6. The order is 10/6, not 2/6. It's 10/6.
10/6.
Yes.
Okay, 10/6. So there are 2 IA in this petition.
Yes, Lordship.
One is for amendment and other is for impletement.
Implement, my lord. My lord, on the last occasion, on 4th of June, the Honorable Court had directed us to implead the four respondents herein.
Direct.
Because, yes, my lord.
Okay,
Because they were candidates in the recruitment itself.
okay,
Lordship, just to cut short,
lords,
actually, we don't have objection.
There would be no objection, my
Yes.
lords.
okay.
In both IA.
Both sides, okay. Heard, Mr.
Lalsani Masailo.
Learned counsel for the applicant. And Mr.
JC for
Learned
MPSC, Mizoram Public Service Commission.
Learned counsel for the respondent. Number 1, 2.
4, Your Lordship.
1 to 4. 1 to 4. This interlocutory application on
My note, 3 to 6 MPSC.
3 to 6.
No, 4 to 6.
4 to 6. 4 to 6. For rest of the respondents,
Hello, even government advocates also will not object. I spoke to her also.
okay,
Because it's a main is MPSC.
okay. So, madam, you are appearing for the state respondent. No objection.
Yes, Your Lordship.
Okay. This interlocutory application under Order 6, Rule 17, reduced Section 151 of the Code of Civil Procedure is preferred by the applicant for amendment of the writ petition number 68 of 2026. The learned counsel for the applicant submits that due to subsequent development, there is a requirement of amendment of the writ petition And the same has been stated in paragraph number 8.
My lords.
Paragraph number 8 of this interlocutory application. From Roman 1 to Roman 3. Roman 1 to Roman 3. And as such, he is contented to allow this application. The learned counsel for the respondent authority submits that they have no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The writ petition number 68 of 2026 be amended as prideful. Now, as indicated in paragraph number 8, Roman 1, Roman 2, and Roman 3 of this interlocutory application. In view of the order passed in this interlocutory application, the petitioner shall file amended writ petition within a period of 1 week from today.
My lord.
And in I number 125 of 2026, pardon me, so and so, learned counsel for the petitioner and the respondents. This interlocutory application is preferred by the applicant for impleadment of under Order 1, Rule 10 of the Code of Civil Procedure for impleadment of one David Lalt Lamoa as respondent number 7, one Sri Ace Lal Rutfaila as respondent number 8, and Sri Lal Rem Ruta as respondent number 9, and Srimati Ace Bhanlal Purai as respondent number 10 in writ petition number 68 of 2026. The learned counsel for the applicant submits that this interlocutory application is preferred as per direction of this court in the order dated when it was
4/6
directed?
4/6/2026, my lords.
4/6/2026. 4/6/2026. And as such, he has contended to allow this interlocutory application by impleading the aforementioned persons as respondent number 7, 8, 9, and 10. The learned counsel for the respondent submits that they have no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. So and so shall be pleaded as respondent number 7, 8, 9, and 10 in the WPC number 68 of 2026. In view of the order passed in this interlocutory application, petitioner shall file amended cause title of the writ petition number 68 of 2026 within a period of 1 week from today. This shall list the matter after reopening.
My lords, after reopening.
Well, can you have fixed, at least can you have fixed date?
Okay, suggested it. July 14th.
We're fine.
My lord.
Lordship. Much obliged.
Deeply obliged, my lord.
Item number 13.
Your lordship, that this appeal was filed under Order 41, read with Section 96 of CPC as well as Section 17 of Mizoram Civil Courts Act against the impugned order dated 7/11/2025 passed by Civil Judge Senior Division 3. And in this case, my lord, the appellant has submitted the airship application for issuance of two properties, two LSC, located at Durklang, and the Honorable Court had accepted and told us to publish the application in the local newspaper for a period of 30 days. And we have published, and later on the objection was filed in the lower trial court, and later on and it was rejected after receiving the objection. My lord, if I may take you to page number 1, the impugned order passed by the Honorable Civil Justice.
Okay, let notice go at this, is this?
My lord, I'm appearing for the sole respondent
So
as a legal aid counsel, my lord, yes.
okay.
I just want to raise the maintainability of this appeal only. Yes. Pardon, my lord.
Why?
Because, my lord, this appeal is filed under, as stated by my learned friend, it is filed under Order 41, read with Section 96 of the CPC as well as Section 17 of the Mizoram Civil Courts Act. So, my lord, the order which they have impugned is not a decree, my lord. This Section 96 of the CPC, if my lords may
Is
have-
against a decree.
Yes, my lords, it relates to only decree, and Order 41 as well. It's an appeal from original decrees.
Decree.
So the order which they have impugned is not a decree, my lord. So they've, this present regular first appeal is not maintainable, my lord. It's only
But,
it's only an order passed in an application, my lord. So it cannot
No,
be.
but you see, several such appeals are pending before this court against the heirship certificate.
I understand that, my lord. Yes. And my lords, if my lords will.
My lord, the main reason is after receiving written objection, we are not given any chance.
Pardon?
After receiving the written objection, it was straightly rejected. So we are not given any chance to counter the written objection filed by the other party. That is the main reason why we came with this honorable
No,
court.
that's all right. In that case, you can challenge the order under Article 227 of the Constitution.
That is my point, my lord. They have to come under revision, my lord.
So you see the Section 96, it is against the decree. If the order passed by the learned trial court is not a decree, then you cannot maintain this petition, this appeal. Order 41 also against original decree.
My lord, if possible, may I kindly withdraw the application
Okay,
and file liberty.
you come prepared. Then
Yes, my lord.
we'll list the matter on some other day.
My lord.
Heard, Mr.
Zodin Pen of the-
Learned counsel for the appellant, and also heard, Mr.
Sitlan Tiang Lim.
The learned counsel for the respondent has raised the question of maintainability of this petition as the impugned order passed by the learned civil judge senior division number 3 Aizal in respect of heirship certificate application number 1029 of 2025 is not a decree, whereas the present appeal is preferred under Order 41 read with Section 96, which are only against the decree passed by the learned trial court. This is this learned counsel for the appellant submits that he may be granted some time to respond to the submission made by learned counsel for the respondent. Fair allot or SSL is the matter. When?
Monday, my lord, 29th
29.
of June.
Much obliged.
Obliged.
Item number 14.
Lordship, this is an appeal, MSCT appeal.
Yes.
I have been directed to take steps
Yes.
So this is, steps has been taken. I don't know whether
Heard, Mr. Your name, please.
Kailaudin Liana.
Learned counsel for the appellant. Office note dated 19/6/2026 indicates that neither ready card nor unserved notice issued to the respondent number 1 How many respondents are here?
Lordship, 3 respondents, Lordship.
Neither ready card nor unserved notice in respect of respondent number 2 and 3 received back by the section. However, said office note also indicates that notice issued to the respondent number 1 returned unserved on 11/6/2026 with a remark, postal remark, the postal note with an inverted comma RTS, and that TCR has also not yet been received. In view of above, the learned counsel for the appellant is directed to obtain instruction in respect of the address of respondent number 1 and to take fresh step upon respondent number 1 by speed post and also by usual process within a week from today, and await service report upon respondent number 2 and 3. Meanwhile, the registry shall also track the consignment in the department website of the postal department and put up one up-to-date office note in respect of the service of notice. And further, the registry is directed to issue urgent reminder to the learned tribunal for transmitting the TCR. List the matter after 4 weeks.
Yes, Lordship.
Item number 15.
Lordship, as directed by this honorable court, step has been taken for service of notice upon the respondents.
Lordship, we have received notice from respondent number 1 and we will represent in respondent number 1 in this matter.
You are for respondent number 1.
Yes, Lordship.
Number 1. Heard, Mr. So-and-so, learned counsel for the appellant. Mr. So-and-so, learned counsel for the respondent number 1. Office note dated 5/6/2026 indicates that snip upon respondent number 1 to 3 was taken on 5/6/2026 by speed post. And also office note dated 18/6/2026 indicates that TCR has been called for, but the same has not yet been received. Accordingly, it is provided that registrar list the matter after the vacation, awaiting service report upon respondent number 2 and 3, and also issue reminder to the learned tribunal for transmitting the record, transmitting the TCR forthwith. Registrar also track the consignment in the website of the postal department in respect of respondent number 2 and 3 and put up one up-to-date office note on next date list after vacation.
Yes, sir. Thank you, Your Lordship.
Item number 17.
May I please, Lordship? My Lord, the present second appeal is directed against the order passed by the district judge as well as the order passed by the senior civil judge. Facts of the case in brief is that the LSC of the respondent number 5 has overlapped the LSC of the pro forma respondent, my Lord. Hence, the respondent number 5 instituted a civil suit number 77 of 2018 against the state respondents, challenging the order dated 3/11/2017 issued by the respondent number 3. During the pendency of the said suit, respondent number 5 filed application under section 151 of the CPC for transfer of location of his LSC from Punchong village to Zonom village. As a result, the learned senior civil judge passed the impugned order dated 7/3/2022 without verifying whether the said vacant land is really vacant at the relevant time of the application, or without knowing whether he has jurisdiction to do so, and that too without giving opportunities to the parties concerned, my Lord. On going through the revenue laws, my Lord, the civil court does not have any jurisdiction, it seems. I have noted down the provision. Allotment of land is the purview of the state government only, the revenue department, as clearly indicated here in the section 16 of the Revenue Act. Allotment of land is the government subject to the availability of land free from all encumbrances and subject to appropriate recommendation of the site allotment advisory board, as may be constituted by the government from time to time.
Whether you have taken such a plea before the first appellate court?
Yes, my Lord.
You have taken.
We have. However, the first appellate court simply gave us liberty to file a fresh suit. There is no question of filing any fresh suit, my Lord. What the first appellate court is to see is whether...
Yesterday,
my Lord.
I have instructed your junior,
my Lord,
to
whether
tell you.
Substantial question of law?
Yes.
Right. I have submitted proposed substantial question of law in my appeal petition, my Lord. Page 21A.
21A.
21A, my Lord. 21A. Proposed substantial question of law. I have proposed substantial question of law at page 21A. Number 1 is whether the learned senior civil judge committed gross error in passing the impugned order dated 7/3/2022 under section 151 of the CPC in civil suit number 77 of 2018 without any jurisdiction.
That's all right.
My
You
Lord.
have suggested substantial question of law,
Yes, my Lord.
but is it part of the memo of appeal?
Yes, my Lord, it is there. Part
A
of,
copy enclosed with the memo of appeal.
I have enclosed this.
You see subsection 3 to section 100 CBC.
Section 100,
Subsection 3.
subsection 3. With the Lordship permission, I'm reading. In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. As a
Whether
result,
you have mentioned in the body of the memo of appeal.
this particular proposed substantial question of law has not specifically mentioned. However, I have enclosed these three proposed substantial question of law in my memo of appeal.
But the question is, can it be said that you have complied with that subsection 3 to section
I
100?
believe, my lord, I believe I have complied with. However, if your lordship is of the view that I have to enclose this proposed substantial question of law in my memo of appeal, then some amendment sort of can be done. If
Yes.
this can be accepted. If
Yes, you can mention it in your memo of appeal. Here
The
you
pra-
enclose it as a low sheet.
Right, my lord. The practice out here, we hardly do that kind of thing. I mean, whenever we, since as per provision, since it is the honorable court which is to frame the substantial question of law, not the council, not the parties. However, we can submit the proposed, we can only propose the substantial question of law, and it is entirely up to the court to reframe or frame a substantial
No,
question
that's
of
all
law.
right, but it is the mandate of the legislature that it should be mentioned in the memo of appeal.
My lord, if there is a case, then I can
And
do it
not
again.
only that, there is one decision of the Supreme Court also.
My lord.
I have not remembered the citation, where it is stated that the appellant shall briefly state in the memo of appeal the suggested substantial question of law. There is one decision.
My
It
lord.
may be Santosh Hazari or someone else. I have not remembered the citation right now. So better you file amended memo of appeal
My lord.
incorporating the substantial question of law,
Right, my
suggested
lord.
substantial question of law. Let it be in the next week.
My lord.
So in principle set, now this is the practice.
My
It
lord.
could be incorporated in the memo of appeal.
Yes, my lord.
And I have insisted there. And if I don't insist the same thing here, then it would be
I
it would
understand, my
send a wrong signal.
My lord, I do
Therefore,
understand that.
so please incorporate the suggested substantial question of law in the memo of appeal, and we will list the matter in the next week.
My lord.
Heard Mr. So-and-so, learned senior counsel assisted by Ms. So-and-so, and also heard Mr. So-and-so, learned counsel for the respondent number.
And for the respondent number 5, my lord.
Respondent number 5, and madam for respondent number
1 to 4.
1 to 4. Having gone through the memo of appeal, this court finds that the appellant has not incorporated the suggested substantial question of law in the memo of appeal. Rather, it is suggested in a separate piece of paper after the affidavit of the memo of appeal. And as such, it cannot be said that this appeal is filed complying with the provision of subsection 3 to section 100 of the Code of Civil Procedure. The learned counsel for the appellant submits that he may be granted some time to file amended memo of appeal incorporating the suggested substantial question of law. Fair allowed, rest shall list the matter on next Monday then?
My lord. Next Thursday, my lord.
Thursday.
My lord.
Thursday. Next Thursday.
2nd July, my lord.
2nd July.
Yes,
Okay,
my lord.
2nd of July.
My lord. Obliged.
Obliged.
Anyone for hearing? To hearing item number 5.
My lord, the leading counsel, he has some personal difficulties, my lord. So if it may be listed, after a week or after the vacation, my lord.
My lord, if it can be expeditiously disposed of, I understand that if my learned friend is having personal difficulties, but this is due to this appeal which is pending, your lordship. Now the ongoing process for releasing the amount, that is my life insurance benefit, now it has been deferred. So that is the reason why there is urgency arose.
No, that's all right. With a view to dispose of the same, this matter is listed today. But if the council is absent, then what to do?
At least it may be taken up on 2nd of July, my lord.
2nd of July.
Yes. So with an attempt I think we can have an attempt to dispose of the matter.
Okay.
It's a simple matter only, my lord. He claims that it is a family property, but I say that it is personal property. And that was also the view of the learned trial court. And injunction was granted to them, to the present appellant. Then I applied for discharging it, then it was granted. Being aggrieved, they filed the FAO now.
There was a nomination.
Nominee, yes. The present appellant is a nominee only, but Supreme Court's judgment is very
Yes.
clear. So long as I'm alive, the policy holder, so he can't have any say. But still he's claiming.
Heard, Mr.
J. Srikil Al Rothfeld.
Learned counsel for the appellant and Mr. So-and-so, learned counsel for the respondent. The learned counsel appearing for the conducting counsel, Mr.
My lord, T. Lalun Siamat, the leading counsel.
Submits that the conducting counsel has some personal inconvenience today, and as such, he files for leave to lack accommodation today. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that SSL is the matter on 2nd of July.
2nd of July, my lord.
On that day, an endeavor will be made to finally hear and dispose of the matter.
Highly obliged.
Obliged, my lord.